Well, hello everyone, and welcome to Uncivil Law. As always, I hope you're having a nice day, and we're here with something different than we've done on this channel in quite a while. We've done this before, kind of. It's been a while since we've done this. We're going, we're going to listen to a question. We're going to answer it ourselves. So this is going to be fun. So I saw this pop up on my feed. Apparently, there's another attorney playing Ace Attorney, and he's on part 15 of his Ace Attorney series. And during the start of part 15, he's at least 15 parts into it. And at the start of part 15, he apparently decided to start part 15 of the Ace Attorney series by relaying a real bar exam question that was asked on the 2019 Ohio State Bar, which apparently is weird and convoluted. I've not heard this question before, so I don't know how weird or convoluted this is. But we're going to read this thing. And Kobe says there might be another one. Hey, Kobe, maybe we can do yours afterwards. So we can do your weird twerk question. Maybe we'll do it first, depending on if it's different. So I don't know how hard this is. I don't know how weird this is. Maybe it's not weird. Maybe it'll be a complete letdown. I don't know. We're going to listen to this question. I've got some paper and pen over here in case I need it. And usually when someone says really convoluted bar exam question, the first thing that comes to mind is real property. Because real property can get really weird. You know, with different covenants and different deeds and life estates and tenants in common, joint tenants of the entirety, residual estates, land rights, water rights, adverse possession, deed races, who owns Blackacre. So normally when I hear a really convoluted bar question, the first thing that comes to mind is, we're going to be asking who owns Blackacre. Because that's usually what the really convoluted question is real property. So we'll listen to this and figure out if it's a real property question. I know nothing about the question. So we're going to listen to this question and answer it, I guess. I don't know. It could be nothing. Yeah.
What's up and welcome back to another episode of Phoenix Wright Ace Attorney with an actual lawyer. Once again, I'm your host, Zach, joined by our actual voice actor, Wes.
Heyo.
And of course, our actual lawyer, Pridge.
Hi, Pridge.
A fun way to start every stream. I'm going to read you guys an essay question from the Ohio 2019 July bar exam.
Oh.
And until chat can combine their powers to give me a satisfactory answer, I will refuse to start the show.
That is amazing. Holy shit.
That's the funnest thing we've ever done.
Yes.
All right. One afternoon in suburban Anytown, Ohio, Mom was working in her home office when she saw on the screen of her home security camera that a person took from her front porch a small package that was just delivered. Believing the person was a thief, and this character is now named Thief, had taken the book set that Mom ordered for her 10-year-old daughter.
Okay.
Mom grabbed a large stapler from her desk and ran outside to stop Thief and retrieve the package.
What a weapon choice.
Mom ran up. No, these are great because listen how this escalates.
Okay.
Mom ran up behind Thief and threw the stapler at him, hitting him in the head and knocking him to the ground. Mom retrieved the package, then she ran back into the house and called the police. After Mom got off the phone, she stood near her front door to wait inside for the police. Mom then saw through the window that daughter had just gotten off the school bus and was walking towards the house.
Oh no.
Fearing for the safety of daughter because Thief was still outside lying on the ground, Mom grabbed her pistol and went outside to escort daughter into the house.
What?
Seeing Mom approach with her gun pointed at him, Thief grabbed daughter and threatened to take her in his car if Mom did not let him flee the scene.
What the fuck?
Okay, so, okay, this is pretty convoluted bar exam question already. Good. Great. So just to recap the story. We have a package delivery. Mom sees package being taken from her security camera. Mom runs out with stapler, throws stapler at thief, apparently knocks him out, or disables him in some way, goes back inside, daughter comes off bus, mom goes out with pistol, thief takes daughter captive. Good. That's good. Okay. All right, let's press on.
Mom continued pointing the gun at Thief and told him to take his hands off daughter or she would
Where's
shoot him.
the question?
It's at the end. It's at the end. Thief simply laughed and continued pulling daughter towards his car and threatening to take her with him if mom did not put down the gun and let him leave. Afraid that Thief would follow through on his threat, mom aimed the gun and shot Thief in the leg. Thief fell to the ground and daughter was able to run into the house.
Mom's a fucking
I'd like to note that this is probably going to come up in the exam question one way or another, but I'd like to note that the time that mom is shooting Thief in the leg, apparently Thief is in quasi-possession of daughter. So daughter is presumably being put at risk in this situation. So there's that. Let's press on.
crack shot.
Last paragraph. Mom then stood over injured Thief, pointing the gun directly at his head.
Jesus.
As Thief was calling Mom crazy and pleading for his life, Mom laughed and repeatedly threatened to shoot him in the head.
Jesus, fuck.
When the police arrived approximately 20 minutes later, they took Thief into custody. Although Thief was charged criminally, he filed a civil tort action against Mom in an Ohio court. And the actual question is, what intentional torts did Mom arguably commit against Thief, and what defenses, if any, might Mom reasonably assert against each alleged tort?
Okay, we can do this. We can explain fully, right?
And I believe,
God.
and on the bar exam, you're given 6 of these essays. And
All right, so let me just go back to the moment of the shooting here, so we can get that detail. Let's just listen to that again.
daughter towards his car and threatening to take her with him if Mom did not put down the gun and let him leave. Afraid that Thief would follow through on his threat, Mom aimed the gun and shot Thief in the leg.
Yeah.
Thief fell to the ground and daughter was able to run into the house.
Mom's a fucking crack shot.
Yeah,
Last
mom
paragraph.
is a crack shot.
Over injured Thief, pointing the gun directly at his head.
Jesus.
As Thief was calling Mom crazy and pleading for his life, Mom laughed and repeatedly threatened to shoot him in the head.
Jesus, fuck.
When the police arrived approximately 20 minutes later, they took Thief into custody. Although Thief was charged criminally, he filed a civil tort action against Mom in an Ohio court. And the actual question is, what intentional torts did Mom arguably commit against Thief, and what defenses, if any, might Mom reasonably assert against each alleged tort? And I believe,
God.
and on the bar exam.
All right, so we can do this. This isn't actually too bad. This isn't actually too bad. We can do this. This is not Who Owns Blackacre. This is not that complicated, really. All right, so let's just. I will tell you the story again that you just heard from them. This is part of me explaining it to myself, right? So, okay, let me explain it to myself. All right, now that we've heard it. Okay, so mom sees guy take package from porch. Mom goes out with stapler, throws stapler at guy. Guy is rendered disabled in some way. Mom goes inside to call police. Daughter comes off bus. Mom goes out towards daughter with gun. Thief is now kidnapper, taking daughter in possession and towards a car and saying, like, let us go, or the daughter gets it. How he's presuming to give the daughter it, I don't know, because he doesn't appear to have a weapon, but we'll get to that in a second. Anyway, so mom apparently here decides it's a good idea to shoot at Thief, who, I'd like to remind you, is currently in possession of daughter. So that means that daughter's in the way here, and we're shooting at Thief. But apparently it worked out because we hit Thief in the leg. So that was good. And then the police show up and arrest him. And the question is, what civil torts did Mom allegedly commit, and what defenses do we have? Okay, that actually isn't that bad. We can do that. All right, so here's what I would say. So we have 3 potential incidences here. Yeah, we also have with I also forgot the gun to the head, laughing, and what was exactly there was the gun to the head thing. Hold on, I forgot that detail. Hold on.
Calling Mom crazy and pleading for his life, Mom laughed and repeatedly threatened to shoot him in the head.
Jesus.
Okay, so just pointing the gun at his head, threatening to shoot him, and laughing until the police arrive. Okay, great. So this isn't that bad. We can do this. All right, so we got 3 different potential incidences in play here, right? That I think we can analyze. We've got the throwing of the stapler, we've got the gunshot, and we've got the gun to the head. There's no other torts I can see in play. We've got some combination of assault and or battery in these actions. So, yeah. And is there anything else that's here except for these 3 incidents? We've got, this is where we have to really read the question, make sure that we're getting this completely properly. All right, so Mom runs up behind thief and throws stapler at him. So he didn't see it coming the first time. So that's just going to be battery, not assault, right? Because we're behind thief, throwing it at him, hitting him, but he didn't see it coming. So assault is not in play. Battery is in play.
After Mom got off the phone, she stood near her front door to wait inside for the police. Mom then saw through the window that daughter had just gotten off the school bus and was walking towards the house.
Uh-huh.
Fearing for the safety of daughter because thief was still outside lying on the ground, Mom grabbed her pistol and went outside to escort daughter into the house.
What?
Seeing Mom approach with her gun.
Seeing Mom approach, right? So seeing Mom approach with gun, so possible assault.
Thief grabbed daughter and threatened to take her in his car if Mom did not let him flee the scene.
What the fuck?
God.
So
Mom
we can analyze that.
gun at Thief and told him to take his hands off daughter or she would
Where's
shoot
the
him.
question?
Assault.
Oh, it's at the end. Thief simply laughed and continued pulling daughter towards his car and threatening to take her with him if Mom did not put down the gun and let him leave. Afraid that Thief would follow through on his threat, Mom
aimed the gun and shot him. Great. So now we've got battery.
Daughter was able to run into the house.
Right.
Fucking crack shot.
Last paragraph.
And then finally we got assault with the gun pointed at the hand.
The gun directly at his head.
Jesus.
As Thief was calling Mom crazy and pleading for
And then
his
some laughter, which doesn't really do anything for anybody. Okay. So we got a pure battery. We got a pure battery. So the first thing that we can do, so we got now 4 incidences, I guess. We got a pure battery. We've got the potential assault as she's running up to him with the gun and he sees her coming. Then we've got a battery related to the gunshot, and we've got another assault as she's pointing the gun at his head and laughing. Okay, so we got 4 potential incidences we can analyze. Okay, great. So let's do that. All right, so incident number 1. Right. So incident number 1 is, okay, Mom takes stapler and throws it at guy's head. All right. So we can analyze whether this constitutes an assault or constitutes a battery. In assault in civil law and in common law definitions, because this is how we do it, right? So we go off the common law definitions unless it's specified otherwise. So in common law, an assault is the apprehension of threat. And since the thief was running away at the time and did not see it, and since Mom didn't call it out or otherwise indicate her presence, according to the hypothetical, there is no potential assault in the throwing of the stapler. The thief didn't see it. The thief didn't hear it. It just happened. So there's no potential assault in common law. So we can strike assault right off our list. That makes that easy. Great. Now we can go to battery. All right. So what is battery? Battery is a unwelcome touching that is in a socially unacceptable context. So there's a subjective and objective element to that, right? So in order for something to be battery, it has to be subjectively unwelcome. So if you want it, it's not battery. You know, if you want the thing to happen, it's not battery. And there will be a lot of things that you might want to happen that might be considered socially unacceptable depending on the circumstances. But if you subjectively want to happen, battery it does not make. So you have to subjectively want it to not happen, and objectively, people in general have to want it to not happen. So if you are a delicate little wallflower, then you don't get that battery unless unless the person has specific knowledge of that. So if you tell someone that you don't want a thing, even if it's objectively unreasonable, they win. So yeah, people do get control over their own body, right? And you can answer some more nuanced points in there somewhere along the way. If the person maybe is asking for something that's completely unreasonable, or asking like it's unavoidable, maybe you could do some other analysis there. But as a general, let's stick with general proposition, right? So a battery is something. Now why is Streamlabs giving me old things? That's an old super chat. Streamlabs is behaving badly. That's a really old super chat. I don't know why it's popping that up there. Anyways. All right. So it has to be subjectively and objectively unwelcome, unless the person who's committing the battery, and now Streamlabs is going to give me every chat for all time. Thank you, Streamlabs. I wonder if I could put Streamlabs in timeout. Yes, I can. Stop. Stop. Thank you. All right, great. Yeah, so in order for it to be a battery, it has to be subjectively and objectively unwelcome. Unless the person who's committing the offense knows that it's subjectively unwelcome, in which case their subjective intent will count. So if they don't know, then it's just what is objectively unreasonable. So here, there's no prior communication between, I know, I did the other day too, I don't know why. So anyways, here there's no prior communication between thief and mother. So mom is unaware of any subjective preferences from thief. So therefore, we'll just go to what is subjectively and objectively unreasonable. So is it subjectively unreasonable? We'll just assume that it is, that thief probably doesn't want this. And because thief is suing. Thief is suing, so we know he's on. Well, it's actually, the call of the question is what is possible. We don't even know what thief wants. We're asking what's possible. So we'll assume that thief wants to sue. So we can assume, therefore, that it's subjectively unwelcome. Is it objectively unwelcome? Yes. Throwing a stapler at the back of the head of somebody is objectively unreasonable if they're running away from you. And you'll think to yourself, aha, but this is different because they're running away with her package. And then you say, well, now we're thinking about defensive property, right? So can we get a defensive property? And here we are using non-lethal means. We'll assume it's a little bit unspecified, but I guess we can analyze it both ways. Whether or not you can use non-lethal force in defending property or lethal force in defensive property. So the first thing that we would consider is, of course, lethal force in defensive property. And in the vast majority of states, of course, that's not going to fly. It doesn't fly if you see it happening. It doesn't fly if you knew it in advance. You can't set up a booby trap. You can't set up the proverbial spring gun. You can't use lethal force to defend property as a general proposition. So so that's not going to work. In order for defensive property, you can use non-deadly force to protect property that is in the defendant's lawful possession, which I think it is, because it is in their lawful possession even though they're not holding it. But yeah, you can use non-lethal force to defend property if it's in your possession, if the force appears to be reasonably necessary to prevent or terminate unlawful intrusion or interference with the property. So here I would say, we're assuming so here we could say, is the property within the valid possession of homeowner? Well, it was left on her porch. So we don't know for sure if it's her package. I guess it could have been left by someone, but it was delivered to her. So she has reason to believe it's her property. And so we can therefore reasonably conclude that the item in question is her property. It would be in her lawful possession because it's her property. And she's using non-deadly force, the stapler. We're going to again assume it's a non-deadly stapler, although questionable. So we need to specify that on the bar exam as well, that we're making these assumptions. So it's a non-deadly force stapler, but we are throwing it at the back of their head. So actually we can't actually make that assumption. So now we have to analyze it both ways. So because we're throwing it at their head, okay. And we don't know the situation about the ground and stuff. So now we actually have to analyze it both ways. So if it is lethal force because the mom is aiming it specifically at the back of the head, and apparently it caused sufficient damage when this happened to cause the thief to be incapacitated in some respect, whether he was knocked unconscious or whatever, he apparently appears to be knocked to the ground or something, so apparently a fairly serious force, right? Then you can't use lethal force to defend property. What is lethal force? Well, lethal force would be force that is likely to cause damage, cause death or significant bodily harm. Does this qualify? Maybe, because you're throwing it right at the back of their head, and apparently it was a heavy enough stapler to cause the guy to do this. So, did she use a deadly weapon in defense of property? Maybe. I mean, you could argue it, right? This is what the whole point of the question is, guys. We have to think about what's possible, right? We don't necessarily have to think about what's likely. We have to think about what's possible. So can we reasonably argue that the use of the stapler is actually deadly force in this situation? Yeah, I mean, we did throw it right at the back of his head, and it did apparently cause significant bodily damage in terms of him falling down. So, good times. So we can analyze that question, then say, of course, if it's deadly force, it's improper. If it's non-deadly force, then it becomes proper. It becomes proper if it's lawfully in her possession, which it is, even though he's technically holding it, but it is her property, and she is trying to terminate that intrusion to property, and we could argue about whether this appears reasonably necessary, which, given the time frames available and the item that she used, yeah, seems probably reasonably possible. So how are we doing so far? We're doing okay so far. Yeah. So yeah, we're doing okay so far on the bar exam question. So we've only got to step one, right? We've only gone to the stapler being thrown at the back of the head. The stapler being thrown at the back of the head. It is not an assault because he didn't see it coming, didn't hear it coming, so it is not assault. It's definitely a battery. It's subjectively unwelcome, and it's objectively improper. What are the defenses? Because normally when someone is throwing, in case you're wondering, by the way, what a socially acceptable battery would be, like, a battery is any kind of unwelcome touching that is not subjectively reasonable or not objectively reasonable in a situation. So what would be an example? We are passing in a corridor, like we're passing in a relatively tight corridor, and I brush by you as I'm walking by, right? I just, I'm not trying to do anything. We're just in a relatively tight corridor. You're coming one way, I'm going the other way, and, my clothing brushes against your clothing. Well, I've touched you, haven't I? So I've touched you, right? And maybe you're the kind of person where that is subjectively, you don't like anyone touching you ever. But it's not the kind of situation that society is prepared to recognize, right? So if we're just in a, with no malice and no ill will on my part, we're just passing each other in the hallway and I brush up against you, or even more than that, like it doesn't have to be that light, right? So maybe part of my shoulder catches your shoulder, right? So there's no malice in my head, or I bump into you, or, we're coming through a doorway. Even if I knock you down, there are situations in like everyday life where that could happen, right? So, like you've seen it in 1,000 movies, right? Someone's carrying a bunch of boxes, someone else is carrying a bunch of boxes, they collide, hilarity ensues, right? We can assume that even if it knocks you on your ass, but it's so it might be subjectively unwelcome, but it's not the kind of thing society is prepared to recognize because no one had any ill will. It's societally reasonable. So that's the kind of thing that we are talking about when we're talking about that. So in this situation, this is not that, right? The person is running away. They're clearly in the open. You're throwing a stapler at the back of their head. This is clearly not going to be not something society is prepared to tolerate. So then we move into defenses, defensive property. And then we can say, okay, you can only use non-deadly force in defensive property. She hit him on the back of the head, so maybe it's deadly force, in which case it wouldn't be permissible. But then again, it is a stapler, and it was non-deadly force, and if it was reasonably necessary to present that, and terminate the interference with property, then so forth and so on. So we have mastered everything about step one of this interaction. Everyone on board so far? Great. Okay, great. So let's move on to step two of this analysis, where she is running towards bad guy as her daughter gets out of the bus, apparently with gun in hand that was it pointed at him the whole time? How is this actually phrased in the call to question? Because there is going to be a difference there. Stop, Streamlabs. You're not welcome around here anymore. You're bad bot. All right, so was she... Let's go back. All right.
Retrieved the package, then she ran back into the house and called the police. After Mom got off the phone, she stood near her front door to wait inside for the police. Mom then saw through the window that daughter had just gotten off the school bus and was walking towards the house.
Oh no.
Fearing for the safety of daughter because thief was still outside lying on the ground, Mom grabbed her pistol and went outside to escort daughter into the house. Seeing Mom approach with
the gun pointed at him. That's the critical language I was looking for there. Seeing Mom approach her with the gun pointed at him. Because I was wondering, did she merely have the gun was she merely holding it? Was she holding it down? What is the state of this? Because it's going to influence the analysis. So he sees the gun pointed at him, right? So that's an assault. What is assault? Assault is the reasonable apprehension of fear. Is there a reasonable apprehension of fear in this situation? Sure. There's a gun pointed at you. I mean, come on. Of course there is. It's easy, right? So there's an assault. And at this point, there's no justification for the assault. There's no reason to point the gun at him, right? Even if there's a reason to have the gun on you. So you could even throw some analysis in here, although it's not really called for in this question. So I wouldn't mention it in this question because it's not really called for in this example. But if you want to throw some stuff in there about castle doctrine and like self-defense. So, I mean, I guess we might as well, just for the hell of it, because we can't lose points by mentioning stuff. So I guess we can say that because young daughter was there and because we knew he was dangerous, that we're in defense of others, but by pointing a gun at somebody? I don't know, man. But if you want to throw some self-defense analysis in here, I guess you could. The self-defense analysis is going to come up later, but I'm not sure about right now. I'm not sure at this point when it's guy who's package thief, who's apparently prone on the ground, and we're just pointing it at him. And I'm not so sure about that one. So if you want to throw in some sort of mom can argue defense of others analysis here, but it's not going to work. So you're going to have to say that's not going to work in the end of that analysis. So yeah, basically it's an assault without breaking a sweat. Mom can try to argue defense of others in the pointing of the gun, but pointing a gun at someone is threatening deadly force, and you can only use deadly force in the imminent threat of death or grievous bodily harm, and there's no imminent threat at the time she points the gun at him. There's no imminent threat. It's just a guy. All that is present is her daughter off a school bus and guy. There's no imminent threat in this situation. So yeah, you can try some self-defense stuff. You might even throw in some castle doctrine because it is her home. So maybe you can argue that the height of the right is, the home. You put in some stuff about the home is special, and she's in defense of hearth and home, in defense of her daughter who's getting off the school bus, who's particularly vulnerable, blah, blah, blah. So if you want to throw some stuff in there, that's fine. But yeah, at the end of the day, I don't think it's going to work. Great. How are we doing? Are we doing good? Is Ohio a stand your ground state? Yes. Does it change anything? Not at this point, no. And even if Ohio wasn't a stand your ground state, we have castle doctrine, and those are technically different things. Castle doctrine applies at the home. Stand your ground applies everywhere else. So, yeah, technically, this isn't even a stand your ground situation. We're at the home. So technically, well, I guess you could have a debate about that if you really want to. Are we really within the home or not? Do we really want to get into whether or not she's within the, what's the word for it? Within the, what's it called? Near your home. I can never, what's it called? That zone right outside your home. It's called the, shit. Hold on, it'll come to me. There's a name for this. The zone that's right outside your home. Curtilage. Yeah, I couldn't get there. Thanks to the chat for reminding me. I couldn't remember. Yeah. So we could get into a debate about whether or not she's within the curtilage of the home. So if she's within the curtilage of the home, then she's inside the home. If not, then she's not inside the home. So I guess we could have a debate. Since this is a bar exam question, I guess we can have a debate about whether or not she's within the curtilage. And so this is, yeah, we can have a debate about whether or not this is curtilage. And so she's within the home, or she's outside the curtilage. So it's stand your ground. So yeah, we could have that debate because she is, after all, running out of her house to get to her daughter who's coming off the school bus, right? So where does her curtilage end, and like, where does her home end in this equation? I don't know. Neither does anyone else, by the way. There's not like some firm definition somewhere floating around, unless there's some obscure statute somewhere that I don't know about. But it's not like there's some obscure statute somewhere that says, well, the curtilage means blah, blah, blah. Nope. There's nothing like that. It's just something we get to analyze every time. So is she within the curtilage of her home, so we're applying castle doctrine, or are we outside the curtilage of her home, so we're applying stand your ground? I don't know, and also it doesn't really matter. But yeah, if you want to throw that in the bar exam because you want to show how smart you are, great. Let's do that too. Yeah, no, she didn't leave her it doesn't appear that she left her property. No. But yeah. Yeah, as I said, castle doctrine only applies in the home. So she's not in the home, she's outside the home. But if she's within the curtilage of the home, she's inside the home, even though she's outside. Don't ask questions. Yeah, but so if she's within the curtilage of the home, she's inside the home, even though she's outside. So the question is she still within the curtilage of the home? Maybe. And if she's within the curtilage of the home, then we apply castle doctrine. Otherwise, we apply stand your ground. So sure, yeah, we can have that debate now that I'm thinking about it. That's great too. But I don't think any of it matters to anything, because at the end of the day, like even if it's inside your home, right, you can't just use deadly force for the shit of it, right? The analysis is the same. The thing about stand your ground, or the thing about castle doctrine, is related to duty to retreat. So the only reason it makes any difference at all is because whether or not you have some obligation to flee. And the law is you don't have an obligation to flee inside your home. And then for states that have stand your ground, you don't have an obligation to flee anywhere. So yeah. So it doesn't like change whether or not you can use self-defense as such. It only changes like what you have to do before you use self-defense. So it really doesn't matter if she's inside her home or not, because either way, she has stand your ground. She doesn't have a duty to flee. But it doesn't change when she can use deadly force. She can only use deadly force in response to an imminent, ongoing, or imminent deadly threat, which just isn't there at this point. So she can't get justification for assault. So she shows she has liability for assault. Yeah. Okay, great. So that is a more comprehensive analysis than I think any of us wanted, but that is definitely a bar exam thing that we could bring up. Yeah. All right, great. So the next up on the list, throwing in the curtilage is just bonus points. Yeah, throwing in curtilage is bonus points. This is just like, how much time do you have for this question? Rachel XOXO says, please take Instagram box. It's distracting. No. Pokey Noodle says it's Ohio Standard Ground. We covered that. Elydian says, what if it's Captain Marvel? Don't start with me. And then a lot of people said curtilage, and then said, YW thinking curtilages make it possible to forget ever again. Okay. All right. Fine. All right. So next up on the list is the shooting. All right. Is mom shooting guy. And remember, we're only looking to mom's potential liabilities here, not bad guys. So yeah. So we have clearly a battery, right? So we clearly have a battery because we have touched another, right? So we can have a whole battery analysis because, well, we can have a whole dicking around contest to explain it to the bar exam because they like that kind of thing. It's like, on the one hand, the mom didn't actually touch the bad guy. You know, she didn't actually touch him with any part of her body, but she did with intent cause an object that she had control of to touch them, and so she's responsible for the chain of events that she directly caused. We could argue some proximal cause here just to make the bar exam people happy because they like that kind of thing, and be like, well, the bullet striking him is a proximate result of her shooting him. So it's connected enough in time to be within the domain, and so yeah, clearly is the result of her actions. So yeah, fun. All right, now we can say, is there a defense? Yes. What is that defense? Well, self-defense or defense of others, right? We just covered this. So you can use deadly force in the face of an imminent or ongoing threat of death or grievously bodily harm. Does kidnapping qualify? Yes. End of analysis, really, on that one. Yeah, kidnapping qualifies as a grievous bodily harm. So yeah, it is actually it's ongoing. It is an ongoing kidnapping. She is literally seeing it happen before her eyes. The bad guy has literally taken possession of her daughter and is headed towards her car. That is an ongoing kidnapping. That would be what we qualify as an ongoing threat of grievous bodily harm. Can she use deadly force to effectuate this? Yes. Yes, she can. Maybe not in California, but we're in Ohio, damn it. In Ohio, she can. By the way, the law isn't really different in California. I'm just giving California a hard time here because they suck. The answer shouldn't be different in California, but they suck. So, who knows what happens in reality there. This is just a poor guy just trying to get by. We need to have more sympathy as a society, and she shot him with white privilege. Maybe that's a valid set of arguments in California, not in Ohio, I don't think. And it shouldn't really be an argument in California either. So yeah, she committed a battery by shooting him. She has defense of others. Another, namely her daughter, is currently undergoing an imminent threat of grievous bodily harm, namely the kidnapping. Yay. So yeah, that's easy. And then we have number 4, which is the assault, with her pointing a gun at his head and laughing at him with that nice touch there as he begs for his life. So, okay. So again, pointing a gun at someone qualifies as an assault. It is reasonable to apprehend a threat to yourself of death or grievous bodily harm. Now, we covered this a little bit when we discussed the Captain Marvel shooting, right? It has to be an imminent or ongoing threat. And at this point, there is no imminent or ongoing threat to her daughter, right? It's just guy sobbing on his knees in the lawn of her home or something. So yeah, you can't, the threats. So what would be the argument? I guess your best argument remains defense of self, defense of others. I mean, what else do you have to work with, right? So you say defense of self or defense of others. Counter argument. There's no ongoing threat. He doesn't appear to have a weapon. He appears to be on his knees. He appears to be helpless. He's been shot in the leg, bleeding out. So counter argument. The threat is complete, right? I mentioned this in the Captain Marvel video, right? The right of self-defense applies if imminent or ongoing, but not complete. Once it's complete, there's no threat anymore. You can't use self-defense in revenge. So the counter argument here is that this is a complete threat. There is no ongoing threat, and she is continuing to use the self-defense. Counter. What's the counter to the counter? The counter to the counter is, there is an imminent threat. What would be the nature of the ongoing imminent threat? The nature of the ongoing threat is still the self-defense, defense of others. We know very recently, like extremely recently, like 2 seconds ago, he was in the process of kidnapping this girl, right? He obviously is willing to use deadly force. Kidnapping qualifies as deadly force. It's not controversial. Exclusions may apply in San Francisco, but for everywhere else, kidnapping is not, it's not controversial to say kidnapping is deadly force. So yeah, so we know he's willing to use deadly force. And while it's true, I guess, in some sense that he's not currently in possession, he could rapidly be because all the players are still in play, right? It's not like daughter has been whisked away to some secure place. It's not like mom has been whisked away to some secure place. The guy is still there. He just was doing the deadly force. So is he an imminent threat? Yeah, I'd say so. I'd say he's an imminent threat. So now you can have a bitching contest about whether he's an imminent threat or he's a complete threat. Right? Is he a complete threat because the threat is over, or is he an imminent threat because he might grab at mom, might grab at another daughter, might steal the boss, whatever, because it like literally just happened 2 seconds ago. And so, yeah, it's probably still an imminent threat. So she's probably in the clear for that. So the only thing mom seems to be guilty of here is pointing the gun at the guy as she's leaving the home. So sure, she's guilty. She's guilty of civil libel. Damages are $1. You know, tell the guy to suck on it. Yeah, she committed assault against you. We don't care. How about $1? How about $1 and you sit there in your sadness? That's the only thing that I think it's liable for. So we did a pretty good thorough analysis, right? All things considered, I think so. Yeah. So where did we mess up and what did we not complete in this analysis? We can hear their answers and see if they came up with anything different. What if mom and dad are one race and thief is another? See, I amazingly enough, at no point in these answers did I even consider their races. It didn't even occur to me to ask, what are the races of anyone involved? So I'm sorry. It also didn't occur to me to ask if mom or daughter are transgender or not. Not that it really matters. Or does it? Or thief maybe. I don't know. Yeah. Couldn't the deadly feast use deadly force by kidnapping as a reasonable reaction? That's a good idea. You could throw that into an answer. The answer is here that your use of deadly force has to be in some way responsive. Like you can't just use it to a random third party. So just to put the point more, give the point more broadly, you know, if I point a gun at you, it doesn't mean that you can now just point a gun at some random third person for no particular reason, right? You can use deadly force against me because I'm the source of the threat. You can't just like point it in general. So no, daughter is in no sense the source of any threat here. So if he's able to use deadly force in response to this, yeah, but the nature of the deadly force in this situation is kidnapping a third party. So, no. But nice idea. Is brandishing anything here? Well, brandishing isn't like a separate tort, but brandishing is what creates the assault. So, yeah, brandishing might be defined in some laws. It's defined usually in some criminal law. But as a matter of civil law, it's just a different subcategory of assault. So, I mean, it's the thing that's creating the assault is brandishing. And the thing that makes it brandishing is that she's pointing it at him, as opposed to just having the gun on her, which wouldn't be brandishing, which also wouldn't be assault. So brandishing is just a species of assault. So we didn't use the term brandishing, but we didn't really have to. Q Squared says, I don't know, those items don't sound like they matter per se, but circumstances when they become relevant. I'm not sure what you mean. Mom says, I'm trained to become a police officer. Assume the thief was identifying as black. I don't know. Last comment in reference to your quip about race and gender and sexual orientation have some angle. Yeah. I just, it didn't even occur to me to ask because someone asked about what if the races are this, and like it didn't even occur to me to ask. And I was like, well, as long as we're asking questions, I didn't bother to ask. Like, what about their transgender status? Of course, it doesn't matter. It didn't even occur to me to ask. So let's see. Let's listen to some discussion. See if they actually have some discussion on this. See what they come up with. See if they come up with anything different than what I said.
Threatened to take her in his car if Mom did not let him flee the scene.
Oh my God.
Mom continued pointing the gun at Thief and told him to take his hands off daughter or she would shoot him.
Where's the question?
Oh, it's at the end. Thief simply laughed and continued pulling daughter towards his car and threatening to take her with him if Mom did not put down the gun and let him leave. Afraid that Thief would follow through on his threat, Mom aimed the gun and shot Thief in the leg. Thief fell to the ground and daughter was able to run into the house.
Mom's a
Oh,
fucking...
well, daughter ran into the house. See, that was a detail we missed. So that was a detail we missed because daughter ran into the house. See, that was a detail we missed. So we have to amend our answer, right, when we're talking about an ongoing threat. Daughter ran into the house. So, yeah, but there's still a threat. We can still argue the ongoing threat, but it does change the analysis because there's no threat to daughter. But he's willing to show deadly force, but there's no ongoing threat to daughter. So the fact that she ran into the house is immaterial. It doesn't really change our end conclusion because the fact that he was willing to kidnap daughter, he could kidnap some other kid, he could act in other ways that are violent. It doesn't change the end answer, but it does change the analysis slightly. So we do have to make a note of that. The fact that daughter ran into the house is material.
Last paragraph. Mom then stood over injured Thief, pointing the gun directly at his head.
Jesus!
As Thief was calling Mom crazy and pleading for his life, Mom laughed and repeatedly threatened to shoot him in the head.
Jesus, fuck!
When the police arrived approximately 20 minutes later, they took Thief into custody. Although Thief was charged criminally.
And 20 minutes later, I guess we could also throw in there because it's like the fact that it's 20 minutes later is also a material fact because you have to basically argue that he was a threat ongoing or imminently for the entire 20 minutes, which again, I think you can do because imminent just means it's imminent. It just means it could happen like right now. Is he an imminent threat? Yeah. Can he be an imminent threat for 20 minutes straight? Yeah. Right. I mean, if someone is holding a lighted match over some kerosene or something, they're an imminent threat, even if that match somehow burns for 20 minutes, because they could drop it at any time. So yeah, but I mean, that's again, you have to mention it. It doesn't change the answer, but it is material to the analysis. Does citizen's arrest come up in some way? It would come up as it comes up as a criminal defense. It's not material. Well, yeah, I guess we did miss one because it was 20 minutes long. I guess we did miss one. We could make a fifth cause of action for kidnapping, false imprisonment. So I guess we did miss one. So that's a dock on me, because it was 20 minutes long. We could throw in a false imprisonment angle because she's not allowing him to leave. So we could say citizen's arrest there. So yeah, that's probably a valid thing. So yeah, we could throw in a false arrest claim and then citizen's arrest as a valid counter. The cops took 20 minutes to arrive. The cops suck. What do you want from me? Which is all the more reason that people should be armed. But yeah.
He filed a civil tort action against Mom in an Ohio court. And the actual question is, what intentional torts did Mom arguably commit against Thief, and what defenses, if any, might Mom reasonably assert against each alleged tort?
So who was it who asked what was the question? Someone asked it recently. Melanie, 16040. Melanie asked, what was the question? The question is, what intentional torts did Mom arguably commit against Thief? What defenses, if any, might Mom reasonably assert against each tort? Explain fully. That was the question. So, yeah.
And I believe,
God.
And on the bar exam, you're given 6 of these essays and 3 hours to do them. So you're basically meant to spend 30 minutes on each essay.
I was gonna say it probably.
Yeah, you. If I did this in 30 minutes, I would miss the false imprisonment. I'd miss it. Because I did. I also missed the fact that daughter fled in home, so I would not be getting a perfect score on the bar exam. You're not supposed to, though. I mean, it's pretty hard to get a perfect score because there's so much stuff. But yeah, there's definitely some things I would have missed on the bar exam versus doing it now. Yeah. Shooting him in the leg is immaterial. It's deadly force either way. So yeah, once you shoot a gun at someone, it's deadly force. So I mean, in terms of the analysis, it doesn't matter that she struck him in the leg. It's deadly force. So she might have made a mistake in so much as, once again, her young daughter, who presumably is very short, is there, and so aiming at his leg while her young daughter is in his custody might pose threat to her, and also like is probably not the wisest course of action, all things considered, when someone's being kidnapped. But apparently she hit her target, so this is on Save Data is the name of this channel. Save Data is the name of this channel. From
It probably takes you an hour to read all of the questions.
Yes, that's what makes the bar exam so hard. Is you have to keep yourself on a very tight time clock.
I thought the final question was going to be like, and what time does the train leaving from Cleveland hit the train coming from Cincinnati? Like, Jesus God.
Jesus.
Yeah, it's a great question because they all start with like a slightly believable scenario, then just escalate it to insanity, just to obviously quiz you on as many different facts of law as possible.
Yeah, what the fuck? Dan in the chat says, and as we all know, the Phoenix Wright games famously take place in Ohio. Just the fact says, shakes my head. Now Zach has to do the intro twice. Oh no, that's definitely staying in the video. I'm sorry if you watch this on YouTube. I can't cut this. That's too good. I'll obviously shorten it, but, wow. Let's get back into the game.
are they not going to answer the question?
Detective Gumshoe was here just
Hey, the detective.
like I promised.
Uh,
Yeah.
All right, I don't think they're going to answer the question, so that's unfortunate. But yeah, I think we found everything between us. I think we found everything. We can even come up with a fifth tort for the false imprisonment because it lasted for 20 minutes. So, yeah, I think we found everything. So we have the initial battery, no assault. We have the assault, no battery. So we have the assault, we have the battery throwing a stapler at his head. We did that whole analysis. We have the assault running out with the gun pointed at him. We did that whole analysis. We have the battery shooting the guy in the leg. Covered that. We have the ongoing assault with pointing the gun at his head, laughing. And because it lasted for 20 minutes, we can also throw in a false imprisonment thing. So what do we think? Battery? Questionable, actually. If it caused any real damage, then maybe, but there doesn't appear to be any damage. So yeah, normally you don't get punitives, right? You just get damages for like what you actually caused in this kind of situation. So there doesn't appear to be any lasting harm. So I guess we can find guilt on the battery, penalty $1. We can find guilt on the assault, $1. The self-defense, the shooting, no problem. The pointing a gun at his head, laughing maniacally, up to you. Up to your call. Let's say assault, $1. We can also throw in, as long as we're doing this also, why don't we just throw in an IIED and NEID threat too? Because it's like, what torts are possible? As long as we're doing it, why don't we just throw in an intentional infliction of emotional distress and negligent infliction of emotional distress in there too, for the hell of it? So we'll come up with the 6th and 7th tort. How much time do we have? We only had a half hour to write the answer. But we could throw in an IIED, NEID while we're at it too, because we pointed a gun at his head, laughing maniacally. The pointing the gun at his head, laughing maniacally, the laughing maniacally part is probably meant to invoke IIED, NEID. It's probably, the reason it's there is probably because of IIED, NEID. But I don't care because he tried to kidnap someone, so sure, $1. And then we can throw in false imprisonment and no, because citizen's arrest. So, I think we've got everything. I enjoyed this sort of. This was fun. If you enjoying this stream, please give it a like as always. This was a little bit different, but we enjoyed this. If you want to watch some other attorney play Centura, you can check out Save Data. And did you know for, it's called nominal damages, not nominative, nominal damages. $1. Nominal damages. Yeah. Nominal damages. $1. Go away. Yeah. If you're, like the stream, give it a thumbs up, subscribe, all the rest of the stuff. I'll see you on guys later. For now, my friends, cheers. Goodbye.